Somewhere in your own family tree, there is very likely a divorce that could not have happened, at least not legally, 40 years earlier. Not because the marriage was any less broken. Because before 1970, ending a marriage in an American courtroom meant standing in front of a judge and proving that someone else had broken it on purpose. That requirement disappeared through a single bill signed in Sacramento on an unremarkable afternoon in early September 1969. No press conference. No headline. A governor who would later call it one of the worst decisions of his career, signing a document that barely made the evening news the day it happened. Nobody at that signing understood what they were setting loose. Not the law professor who helped design it. Not the governor, whose own marriage had ended years earlier inside the very system this bill was about to dismantle. Not the 15 citizens who testified in hearings that led to it. And certainly not the millions of families in every state who would spend the next half-century living under a law they never voted on, never read, and in most cases never knew existed by name. This is the story of how one page of California legislation reached into ordinary households across the entire country, into who kept the house, who raised the children, who could afford to leave a marriage, and who couldn't, and why the argument over what it actually did to American families is still being fought in state capitals today. If the kind of history that hides inside old paperwork and forgotten hearing rooms, the laws nobody remembers voting for, the decisions that quietly reshape everyday life, is what keeps you watching, this channel exists for exactly that. Subscribe, and we'll keep opening these files together. Start with a single family standing in front of a Los Angeles County judge sometime in the 1950s, because that's where this story actually begins, not in a legislature. A wife wants a divorce. Her husband doesn't contest it. Both of them agree the marriage is finished. But California law, like the law in nearly every state at the time, doesn't recognize "we both agree" as a legal reason for a court to act. Somebody has to be guilty of something. So her attorney has already coached her on exactly which words satisfy the statute. She testifies that her husband's conduct amounted to extreme cruelty. The judge, who has heard the identical phrase from a dozen other petitioners that same week, asks a few required follow-up questions, writes down her answers, and grants the divorce. Everyone in the room, including the judge, understands that what just happened in open court was closer to a script reading than sworn testimony. Nobody says so out loud. Legal scholars had a term of art for this: collusive divorce. It meant two people who agreed on everything were required by the state to pretend under oath that they didn't, because the alternative was staying married against both of their wishes. For couples chasing an even faster exit, or one stuck in states with especially rigid grounds, there was a second option: leave the state entirely. Reno, Nevada had built a genuine local economy around 6-week residency requirements. Loose enough to let out-of-state spouses establish just enough legal footing to file under Nevada's easier rules, then go home unmarried. Dude ranches near the city marketed themselves specifically to soon-to-be divorced guests, waiting out the clock, horseback riding by day, a fresh start by the time the paperwork cleared, a whole tourism industry, quietly built on the gap between what people wanted and what home state law would grant them without a manufactured villain. By the mid-1960s, California's own court dockets were choking on exactly this kind of manufactured conflict. Divorce filings were climbing steadily even under the fault system, and judges were saying so plainly in bar association journals and internal memos that requiring sworn perjury as the entry fee for an uncontested divorce was corroding respect for the courts themselves. It wasn't framed at first as a women's rights question or a moral reckoning. It was framed as a plumbing problem. The pipes were clogged with rehearsed lies, and somebody needed to unclog them. That was the assignment Governor Edmund Pat Brown handed, in 1966, to a newly created body, the Governor's Commission on the Family. Its stated purpose sounded almost bureaucratic: study the state's divorce process and recommend fixes. What it actually opened was a much bigger question. What should a modern legal system require, at minimum, of two people who no longer want to be married to each other? Among the 15 citizens who came before the commission to testify, according to one surviving account of those hearings, 14 were men, and 10 of them had already been through a divorce themselves. A striking imbalance, in hindsight, for a reform that would eventually rewrite the legal and financial terms of marriage for millions of American wives, decided in a room where their own voices were barely represented. One person in that room stood out for a different reason. Herma Hill Kay, a young law professor from Berkeley, had clerked for California Supreme Court Justice Roger Traynor before joining Bolt Hall's faculty in 1960. She arrived at the commission already building the body of research that would later make her a co-author, alongside a young attorney named Ruth Bader Ginsburg, of one of the first law school casebooks ever published on sex discrimination. Kay's argument to the commission was specific: a system that forces people to lie about blame in order to end a marriage that both sides already consider over isn't protecting families. It's degrading everyone who passes through it, judges included. The Commission's 1966 report recommended something that read, on paper, like a modest procedural fix, and turned out to be anything but replace the adversarial, guilt-hunting structure of divorce with a single, neutral question. Has this marriage actually broken down beyond repair? Not who did what to whom, just whether the thing itself still existed. Turning that recommendation into an actual statute took 3 more years and ran through the desk of Assemblyman James A. Hayes, whose Assembly Judiciary Committee spent that time negotiating what would survive the legislative process intact. The Commission's original vision had been larger than what eventually passed. It had imagined something closer to a unified family court, one specialized venue handling divorce, custody, and support together, staffed by judges trained specifically for family disputes. That ambition didn't survive. Custody and child support were carved out of the bill's scope, left for a future legislature to sort out on its own timeline. What did survive was the core mechanism: eliminate every fault-based ground for divorce in California. Adultery, cruelty, desertion, all of it, and replace the whole list with one standard: irreconcilable differences. An irremediable breakdown of the marriage. Nothing else required. The bill went further than most reformers had expected it to. It didn't simply add a no-fault option next to the old fault-based grounds, the way some states would later choose to do. It erased fault-based divorce from California law entirely, and it stripped fault out of the financial side of divorce too, meaning a spouse's affair, once the deciding factor in how property was split and support was awarded, could no longer be used to punish anyone financially. Legal historians would later describe it as a pure no-fault system, the first anywhere in the country. By 1969, the bill reached a governor who hadn't sat on the commission and hadn't written a line of it. Ronald Reagan had been elected in 1966 on fiscal conservatism and law and order politics, not family court procedure. But sitting underneath his signature is a personal history most viewers don't know. 2 decades earlier, in 1948, his own marriage to actress Jane Wyman had ended inside the exact system this bill was built to replace. Wyman's filed petition survives in the public record. It states, in its own words, that the couple was unable to live together in happiness. Legal language dressed around the formal grounds of mental cruelty. The same catch-all charge thousands of ordinary California couples were forced to invoke every year just to get a judge's signature on an ending both sides had already agreed to. Biographers and people close to Wyman would later say she'd been more candid with friends about the real reason. She was, by several accounts, simply worn down by evenings spent listening to her husband's increasingly consuming political convictions, years before anyone imagined he'd hold elected office at all. Whether that personal history shaped Reagan's decision to sign the Family Law Act 2 decades later is something historians still debate openly. What isn't disputed is that he had lived at close range and under oath inside the very fiction this law was designed to end. The signing itself happened without fanfare, a few days after Labor Day in 1969. Newspapers that week were consumed with Vietnam, the aftermath of Apollo 11, the opening of a new political season. California, quietly rewriting its divorce law, barely registered as a footnote anywhere outside the legal press. The Family Law Act took effect January 1, 1970, and for its first months on the books, it read like exactly what its drafters intended: unglamorous court procedure housekeeping, cleaning a system everyone already privately admitted was dishonest. Within 5 years, 45 other states had passed some version of a no-fault statute of their own. And that's the moment this story stops being about one state's tidy legal reform and starts being about what happens when you remove the single legal lever that had, however dishonestly, been forcing two people to negotiate before a marriage could legally end. Picture a county courthouse clerk's office in California sometime in early 1970, a few weeks after the new law took effect, sorting through a stack of filings that looked nothing like the ones from the year before. No sworn accusations of cruelty. No staged infidelity affidavits. Just a single checked box, irreconcilable differences. That clerk was watching, from the most unglamorous vantage point imaginable, the opening weeks of what would become the largest shift in family structure of the 20th century. Though nothing about the paperwork in front of her looked historic at all. For nearly a century before that morning, the national divorce rate had followed a remarkably flat line. From 1867 through 1950, it sat at roughly 1% or lower, about one divorce for every 1,000 people in the country, year after year, even through wars and economic collapse. It didn't climb above 2% until 1940. Under the old system, divorce wasn't rare because marriages were happier. It was rare because the legal price of leaving one was so steep. The first year the national rate broke through 3% was 1969, the same year California finalized the law that would become the country's template. That timing alone proves nothing on its own. The late 1960s were already reshaping American life in ways that had nothing to do with any single statute. But what followed over the next decade was too large and too closely tied to exactly when individual states adopted no-fault laws of their own for researchers to wave off as coincidence. Between 1960 and 1980, the national divorce rate more than doubled, from 9.2 divorces per 1,000 married women to 22.6. It kept rising until it peaked between 1979 and 1981, at roughly 5.3% of the population, before beginning the slow decline that has continued into this century. What made California's law spread so fast wasn't only the outcome, it was the delivery mechanism. Kay's involvement didn't end with the 1966 report or the 1969 signature. In 1970, she was named co-reporter alongside law professor Robert Levy of a new project, the Uniform Marriage and Divorce Act, a model statute built specifically to hand other state legislatures a ready-made template so none of them had to run their own multi-year commission from scratch. State lawmakers in Iowa, Michigan, Florida, and dozens of other capitals didn't need to reinvent anything. They had California's finished law and Kay's blueprint sitting on their desks. The adoption wasn't uniform. Some states laid a no-fault option onto their existing fault-based system rather than replacing it outright, the way California had. Others waited a decade or more. By the mid-1980s, legal surveys counted 18 states with pure no-fault systems, close to California's original design, and the rest running some hybrid version alongside older fault grounds. One state held out longer than any other, New York, anchored by a coalition of religious institutions and lawmakers wary of loosening marriage's legal grip, kept a fault-based framework in place for 4 full decades after California's law took effect, until Governor David Paterson finally signed New York's own no-fault statute in October 2010, making the option universal in all 50 states in the District of Columbia. 41 years. That's how long it took the last holdout to fully absorb what a handful of California commissioners had quietly set in motion in 1966. And by the time it finally happened, the country debating it in 20 barely resembled the one that first passed it. Because in the decades between, the consequences nobody on that original commission had spent much time discussing were already rewriting what a divorce actually cost the people living through one. If you've made it this far, was there a divorce somewhere in your own family's history that unfolded under this exact law? Whether anyone in the family realized it at the time or not, did your parents, grandparents, or great-grandparents ever describe how difficult it once was to legally end a marriage? The years it could take, the things a court demanded someone admit to? I'd genuinely like to know whether those memories survived in your family, and whether any of them ever mentioned Reno. Removing fault solved the exact problem it was built to solve. It also, almost immediately, opened a door nobody on the 1966 Commission had spent much time studying, because the Commission's mandate had been narrowly about the divorce proceeding itself, not about what happened financially, or to the children once a marriage was actually over. Under the old system, a spouse's guilt or innocence had done more than decide whether a court would grant the divorce at all. It had also, in practice, showed how much alimony a wife received and how the couple's property was split, because judges routinely treated a finding of fault as leverage, punishing an unfaithful or abusive spouse financially, protecting the party the court considered wronged. It was an unequal, often arbitrary system, but it gave the financially dependent spouse, almost always the wife in a household built around a single income, real bargaining power at the table. She could threaten to contest the divorce, to drag the fault-finding into open court, to make the whole process expensive and humiliating for a husband who wanted out quickly. No fault erased that leverage in a single stroke. A husband could now simply file, check the box for irreconcilable differences, and the marriage would end regardless of what his wife wanted or how the household's finances had actually been built over the previous 20 years. Custody changed in ways nobody had deliberately legislated either. Divorce attorneys practicing through the transition began noticing something the old system had accidentally been preventing: custody fights that were fully separate from everything else. When a divorce required proving one spouse's fault, custody had usually followed that finding almost automatically. The guilty party rarely walked away with the children, and the argument over kids was absorbed into the larger argument over blame. Take blame out of the equation, and custody became its own freestanding battlefield, fought without any of the legal shorthand the old system had provided by default. A letter survives from a Sacramento courtroom transcript of the era, cited by family law historians studying the years right after the act took effect, in which a judge, faced for the first time with two parents who agreed the marriage was over but disagreed sharply over who should raise their children, remarked from the bench that the law had solved one argument by handing him an entirely different one. That single line, buried in an obscure procedural record, captures something the architects of the bill hadn't planned for. They had removed a fight over blame and, without meaning to, created a new fight over children that the old system had never required courts to referee in isolation. The person who did more than almost anyone to put numbers behind what was happening was a sociologist named Lenore Weitzman, who had watched California's reform unfold with real enthusiasm at first. "I started out seeing this halo around the law," she would later say, describing how no fault had initially struck her as an obvious improvement: less acrimony, less forced perjury, a cleaner process for people who were already suffering enough. In 1985, after years of research, she published her findings in a book called The Divorce Revolution, and the numbers inside it landed like a thunderclap in courtrooms, newsrooms, and congressional hearing rooms alike. According to Weitzman's data, divorced women and the children in their households experienced a 73% drop in their standard of living during the first year after divorce. Their former husbands, by contrast, saw a 42% rise in theirs. 85% of divorced women, she reported, received no alimony at all. Picture the room where those numbers first landed with real institutional weight: a congressional hearing chamber in Washington, sometime in the mid-1980s. Weitzman seated at the witness table, lawmakers on both sides of the aisle taking notes as she laid out a portrait of a reform that had quietly impoverished a generation of American women and children. The book didn't just describe a trend. It became almost overnight the single most cited piece of evidence in the entire national argument over what no-fault divorce had done to families. Feminist leaders like Betty Friedan and conservative commentators like Phyllis Schlafly invoked the same 73% figure from opposite ends of the political spectrum. Judges cited it in rulings, newspaper editorial boards built entire arguments around it, and lawmakers folded it directly into the policy conversations that eventually produced the country's modern child support guidelines. Then, in the summer of 1986, an economist named Saul Hoffman, who specialized in divorce statistics at the University of Delaware, sent Weitzman a letter. He'd noticed her numbers were difficult to reconcile mathematically with the income figures reported elsewhere in her own study. A New York sociologist named Richard Peterson eventually went further, gaining access to Weitzman's original underlying data at Radcliffe College's research archive and rerunning her analysis from the raw numbers up. What he found, published a full decade after the book's release, was a real gap, but a far smaller one. Roughly a 27% decline in women's post-divorce standard of living, against a 10% rise for men. Serious, but nowhere near the 73-42 split that had already shaped a decade of national policy. Weitzman, to her credit, publicly acknowledged the error once the reanalysis was confirmed. The correction barely made a ripple next to the original headline. By the time Peterson's numbers appeared in 1996, Weitzman's 73% figure had already finished its work, cited in hundreds of newspaper articles, folded into court decisions, built into the architecture of a generation of family law reform. A flawed statistic that may have shaped more real-world policy than an accurate one ever could have. Simply because it arrived first, sounded devastating, and nobody checked the underlying math for 11 years. What the correction didn't erase was the pattern both versions agreed on. Divorced women really were, on average, worse off financially than their former husbands. No fault hadn't invented that gap from nothing. Unequal wages, career interruptions for child-rearing, and lopsided property division all predated 1969. But by taking away the one legal lever that had given a financially dependent spouse real negotiating power, the law had made an already unequal arrangement far easier to walk away from unilaterally, and much harder for the more dependent spouse to resist. There was a specific kind of woman this new arithmetic hadn't accounted for at all, and by the mid-1970s she had a name, coined by a 60-year-old activist who had lived the exact situation herself. Tish Summers had spent decades running a household built around her husband's income, the way an entire generation of post-war American women had been raised to expect their lives would unfold. When her own marriage ended in the 1970s, she discovered something the architects of no-fault divorce had never had reason to think much about. A woman in her 50s or 60s, with no recent paycheck, no pension in her own name, and now no alimony to speak of. Under the new laws diminished, expectations was functionally unhireable in the job market of the period. Too old for most retraining programs, not yet old enough for Social Security. She had spent her working decades performing labor that no employer's application form even had a box for. Picture the kind of employment office Summers and women like her would have walked into in 1974 or 1975, a folding table, a stack of typed job listings, a counselor scanning a resume with a 20-year gap in it, and no clear way to explain what had filled those years. Picture the kitchen table conversations that preceded it. A woman going through cancelled checks and a shrinking bank balance, working out for the first time in her adult life exactly what her own labor, unpaid for decades, was actually worth on paper. Nothing. According to the forms in front of her. Summers coined a term for that exact predicament, the displaced homemaker, deliberately borrowing the language used for refugees forced from their homes by war. It wasn't a perfect comparison, and it drew criticism at the time for centering a particular kind of white, middle-class experience over the harsher economic realities facing working-class and minority women. But it named something real, and it spread fast. As chair of the National Organization for Women's Task Force on Older Women, Summers, working alongside fellow activist Laurie Shields, built a coalition that eventually reached 39 states and the halls of Congress. The first legislative answer came out of California in 1975, drafted by a young attorney named Barbara Dudley working directly with Summers, the Displaced Homemakers Employment Act, creating pilot centers where divorced and widowed women with no recent work history could get job training, counseling, and something resembling a bridge back into a labor market that had moved on without them. Within a year, similar bills had been introduced in 27 other states. By 1978, the movement reached the federal level when President Jimmy Carter signed an updated version of the Comprehensive Employment and Training Act, specifically funding displaced homemaker programs nationwide. It amounted, in practice, to a second piece of legislation, quietly patching a hole the first one had torn open, proof that the 1969 Act hadn't only changed how a marriage legally ended, it had changed what happened afterward to the people left standing in it. Badly enough that an entire second movement had to be built, state legislature by state legislature, just to catch them. By the time New York finally passed its own no-fault statute in 2010, the California law had done something almost no single piece of state legislation ever manages. It had become, in every practical sense, national policy without ever being voted on nationally. Every American family, whether they knew the Family Law Act by name or not, was now living inside its logic. Marriage, once something the state actively used its legal machinery to hold together, had become something either spouse could end unilaterally, for any reason or none at all, without proving a single thing to anyone. Here is what makes this story different from most quiet legislative footnotes. The argument over what California did in 1969 never actually ended. It went dormant for a while. In the last few years, it has come back with real force. Louisiana built the first formal alternative back into its marriage laws, creating covenant marriage in 1997. An optional legal category couples can choose that requires counseling and imposes far stricter grounds before a divorce will be granted, effectively opting back into something closer to pre-1969 system voluntarily. For years it remained a niche choice. Then in 2023, Louisiana's state Republican Party began openly discussing whether to push for eliminating no-fault divorce statewide entirely. Not as an optional alternative this time, but as a wholesale repeal. Oklahoma followed in early 2024, when State Senator Dusty Devers introduced legislation to strip incompatibility from the state's list of acceptable divorce grounds, effectively requiring spouses to prove fault again, much as California couples once had to. The bill never made it out of committee. It was reintroduced anyway. In South Dakota, a state representative named Tony Randolph brought a nearly identical bill to the floor almost every year between 2020 and 2024, without success and without giving up either. Texas and Nebraska's state Republican parties have both since added language to their official platforms supporting restrictions on no-fault grounds. On the national stage, Vice President J.D. Vance has publicly described no-fault divorce as one of the more consequential shifts of the modern era. A policy, he's argued, made it too easy to walk away from a marriage that might otherwise have survived. None of these efforts has yet succeeded in actually reversing what California started. As of today, no-fault divorce remains legal in some form in all 50 states. But the pattern is a familiar one to anyone who has watched how legal change actually spreads in this country. A handful of failed bills in a handful of states, reintroduced year after year, until public opinion or political circumstance shifts enough for one of them to finally pass. That is, after all, almost exactly how no-fault divorce itself became universal the first time. One state's quiet experiment copied piece by piece until what had been unthinkable in 49 other legislatures became the unremarkable default everywhere. Herma died in 2017. Having spent 5 decades as one of the most influential figures in American family law, still defending the reform she'd helped design as an overdue correction to a dishonest system. Ronald Reagan, in his later years, told his son Michael that signing the Family Law Act ranked among the biggest mistakes of his time in public office, a private regret from the one man whose signature had made it real, arriving decades after the ink had dried and long after the decision was ever his to unmake. What neither of them could have fully predicted sitting in Sacramento in 1969 was how far a single afternoon signature would eventually travel. Not just across every state line, though, it crossed every one of them eventually, into the actual architecture of ordinary life, into who kept the house, who raised the children, who could afford to walk away and who couldn't, and into a legal fight over the basic definition of marriage that is, right now, being argued in state houses most Americans have never once thought to watch. The Family Law Act never ordered a single American to get divorced. It simply changed the one question a court was legally required to ask. Judges stopped asking who had destroyed a marriage and started asking only whether one still existed. That single shift in the question, not a change in how people felt about marriage, just a change in what the law required them to prove about it, quietly rewrote the terms of millions of American lives, one household at a time, most of whom never knew the paperwork behind it had a name at all. The next time your own family's history comes up, a grandparent's divorce, a great aunt who disappeared to Reno for 6 weeks and came home unmarried, a name quietly missing from a family tree. It's worth remembering that none of it happened in a vacuum. Somewhere behind it sits a single afternoon in Sacramento, and a signature from a man who believed he was only fixing a broken court system, with no idea he was rewriting the terms of family itself for everyone who came after him. If this is the kind of American history you want more of, the laws hiding in plain sight, the ordinary paperwork that quietly reshaped everyday life, There's another one of these stories waiting in the next Black Oak documentary, and like this one, it starts with something almost nobody thought was worth remembering.